Courage, because that way the incident between the governor and this lady is not a solitary incident.
Malicious FIR has been started against the petitioner and other staffs of the Raj Bhavan, my lord. My lord, if your lordships take the face value of the FIR, it will not constitute any offence against the present petitioner, and there is a constitutional bar under section 361, article 361, which says, my lord, there cannot be FIR can be registered against the His Excellency, my lord. A harassing, unconstitutional, and out malicious FIR has been started against the petitioner and other staffs of the Raj Bhavan, my lord. Now, my lord, we have challenged the entire FIR. My lord, this is the certified copy of the FIR. I shall not read in open court. If your lordship kindly see it once. Then I shall make my argument before your lordship. First,
Yes.
your lordship see, my lord, the FIR.
No, you start.
If your lordship see the FIR, my lord, kindly
Petitioner is one of the.
Lord, he is the officer on special duty of
Oh,
His
yes.
Excellency
All right.
from his office.
All right.
It's
Yes.
very, very important. If your lordship kindly see it, Lord, kindly see the date of lodging of the complaint, 15/5/2024. My lord, got it? Top of
Page
the,
9, you say?
Lord, the internal page 9. The first
There
is
are
for
two paginations.
the formal
Wait,
part.
wait.
Formal part.
Yes.
Yes. My lord, kindly mark the date 15/5/2024.
Yes.
Then, my lord, kindly see the sections 341
Hmm.
and 166. My lord, 341 speaks about wrongful restraint, punishment for wrongful restraint. The punishment either for, my lord, 1 month or for 50 rupees, 500 rupees. This is the maximum punishment in 341. Although this is a cognizable offense, that is the reason they have started the FIR. And 166, my lord, it is, my lord, the abatement. My lord, it doesn't have any specific definition. Abatement is connected to the original offense. But I shall show your lordships, my lord, none of the offense here in the FIR which is applicable so far the present allegation is concerned. This is number one. And second, I will show your lordship, my lord, if your lordships take the face value of the FIR, it will not constitute any offense against the present petitioner, and there is a constitutional bar under section 361, article 361, which says, my lord, there cannot be FIR can be registered against the His Excellency.
No, but then this FIR is against. You say the petitioner is has also been
My lord,
named in
read
the
the
FIR.
contents, my lord, then your lordship will understand the entire thing, my lord. First, my lord, I shall show it the timeline also. My lord has gone through 341, 166 first.
Yes, 1 minute. Yes.
Yes.
The timeline is there, and
Now, my lord, it is
serial
very
number
important. I
7
shall come by one, my lord. Kindly see
details
the occurrence of the offense. My lord, it is very important.
the
Thursday.
occurrence of the
My lord,
offense.
kindly
was-
marked it. Thursday,
Hmm.
2/5/2024. That means
Yes.
after almost 13 days, they are lodging this complaint. And who is the complainant here? My lord, kindly mark this name. Sabonti Ghosh, Inspector, Hare Street Police Station. My lord, got it, my lord? Kindly
Yes.
mark it also. Now, my lord, kindly turn to the written complaint, which will appear in page 10. My lord, I am not reading it in open court. My lord, kindly read it for once. My lord, then I shall make my submission. Constitutional bar, the FIR itself says 361 regarding the prosecution against the, my lord, His Excellency. That they have stated. Now, my lord, kindly, there are three parts of the FIR which your lordships has perhaps noticed. First part, 19th, asks for the CV. Second part, on 21st, where the actual incident took place, inside the chamber, as per the allegation, my lord. Third part, my lord, your lordship will find on 7/5, my lord, this is the 22nd, my lord, the 2nd of May, she comes out from the, my lord, the place, Raj Bhavan, and lodges the complaint with the police station. She doesn't disclose anything against, so far as the petitioners are concerned. On 7th again, but this is the afterthought I am saying, and the officer who is investigating the matter, it is her brainchild. She says on 7th, my lord, again she came and, my lord, the allegation is this, my lord, that we have.
Did you not implead that?
No, it's a
victim?
suo moto case by the, my lord, the police officer, so we could not implicate her. It's a suo moto case. My lord, kindly see the fourth paragraph, my lord, the allegation so far as the present petitioner is concerned. Kindly see, my lord. On 7/5/2024, the lady further revealed on 2/5. There is a complaint on 2/5/24. That is the previous paragraph. Your lordship will find the lady came to the Hare Street Police Station. Her complaint was received. One person named Supriyo Mollik also joined her for the given mental support. That is ended on 2nd of April. Now on 7th, our name is not mentioned in that complaint. Now 7th of May 2024, the lady further revealed 2/5/2024 when she left the room, so and so, she reached to room and the state of emotional distress. Some Rajbhavan personnel included the present petitioner, OSD on so and so and so and so, asked her not to disclose any fact. But kindly marked it here, pause it here a moment. Admittedly, this lady, she was alone inside the chamber of of His Excellency. There was one person was there. The officer said, "No, you need not be present here." She was alone. Now, this part they are saying, which they are saying that she reached the West Bengal state of condition with included so and so, locked her and asked her not to disclose any fact. Your Lordships knows there is a principle in Bhajanlal, the principle number 5. It says, if the allegation, if your Lordships takes their face value, will not constitute their offense. This is number 1. And second, where the allegations in the FIR is so absurd and inherently improbable. Admittedly, the lady was alone, and the allegation is that we asked her that not to disclose anything. So as if that we know what has happened there, which is absolutely improbable. That is the reason, in Bhajanlal, principle number 5, your Lordships more than aware of me, this principle was introduced, saying that the allegations are absolutely absurd. We are falling in this category. Something happened there. Admittedly, she was alone. Now she is saying we obstructed her and disclosed her not to say anything to her. And the main ingredients of 341, which is the offense which is a cognizable in nature, it says, wrongful restraint. Now, there cannot be a partial restraint. 341, your Lordship will see the paragraph, your Lordship will find the last line it shows, but somehow she managed to leave the room. Kindly marked it, the same para. This will not attract so far the allegation under section 341 is concerned. The restraint has to be a complete restraint. If it is a partial restraint, this will not constitute the offense. So far as 106(16) is concerned, I told your Lordship, it's an abatement and it is a non-cognizable offense. FIR on the first instance cannot be registered. So on these two scores, the FIR should be stayed. Petitioner is the officer on special duty. In page 38, annexure P1, your Lordship will find his appointment letter. And your Lordship will find page 39, when I was in my residence on Sunday, this WhatsApp was given by the Hare Street Police Station. I have page 39, kindly time is also mentioned here. Your Lordship will get it in 1:40 p.m. and asks me to appear on the same day between 3 to 5. That's on Sunday. I was in Delhi. Now, the next page 40, we have annexed the 41A notice. Immediately, this notice was given 1:40 p.m. on Sunday and asking me to appear between 3 to 5 on the same day. 2 to 5. I'm sorry, 2 to 5.
Page 40 is dated 18th of May.
Yes.
And to appear on the 19th of May.
But it was sent to me via WhatsApp, your
19th,
yes,
that you received it.
Yeah. Now, I write a letter to them in page 41 that what is the allegation against me? Please let me know. Because I have a right to know the allegation. As because you have not uploaded, as per the Youth Bar Association judgment, it has to be uploaded within 24 hours. Your Lordship knows in the website. Nothing was uploaded. So we write a letter. Please give us the copy of the FIR and give me a time for 10 days. Immediately another notice has been given to me, page 42, that within 2 days, that is 21/5/2024, between 15 to 17, you appear before us. Now, on the same day, because after getting the notice, being a law-abiding citizen, I returned from Delhi. My boarding pass is page 43. Now, after coming to know the case has been registered against me, immediately, kindly see my bona fide. I surrender before the landed jurisdictional magistrate and obtain bail. Since these are, the 341 is a non-bailable offense. Bailable offense, I obtain bail there. Page 45. Now, 46, your Lordship will find the certified copy which I have applied for the entire case record on the same day. And 47, your Lordship will find on the pretext of this investigation, which is bias, baseless, the unconstitutional and out and out malicious, all the employees of the Raj Bhavan, they have been called by the, my lord, the police authorities. Your lordship will find from 47 onwards. Notices after notices have been given to the officers of the His Excellency, my lord, to go and, my lord, they join the investigation so far as this allegation is concerned.
Portions have been read out from the complaint,
Yes.
which says that the incident took place inside the chamber of His Excellency, and this person was outside. And 2 days later on, she comes up, not 2 days, in fact,
5 days.
5 days later on, she comes up to lodge the complaint and says that she was prevented or restrained by this person and others, because documents have been annexed to show that similar notices are sent out to other employees also. Right? You have all the evidences with you.
Yes.
It is not that the petitioner has any opportunity to tamper or coerce the witnesses or anything of that sort. The 3-4 lines of this complaint appears to be a little bit absurd. I won't say completely, but to some extent absurd. Can we stay the proceeding for the time being till the court reopens on the 10th? The matter will appear and the regular bench will take up the matter.
Could I say this, my lord? Then, my lord, I need to, my lord, disclose a lot of things which possibly will be bordering on, my lord, interfering with the immunity that the governor has. My lord, this was not the only incident which the lady had reported or faced rather. My lord, this had happened at least twice as per her complaint against the governor.
That is against His Excellency.
Yes, yes,
This
yes. Therefore,
person,
yes, yes.
petitioner.
Therefore, my lord, in our state, at least now you will find that people are coming out today, my lord, against these persons. Now, please consider the situation of this lady who could somehow gather courage, because that the incident between the governor and this lady is not a solitary incident, which your lordship may look into the complaint of the lady, my lord, so far as the governor is concerned. Therefore, my lord, once, my lord, she gathers this courage and comes before the police or before the court, my lord, there may or may not be some inconsistency in that. My lord, these, my lord, lines, my learned friend is right. The Supreme Court has said that it should be read with care and circumspection, and also, my lord, taking the overall circumstances. That is
Yes.
very important.
Right.
My lord, please, my lord, whoever is to consider has to consider in the armchair of that lady. It is unexpected that, my lord, the FIR would be like a petition. Now, my lord, some inconsistency here and there, but I don't say that inconsistency is there. But even then, assuming for argument's sake, my lord, your lordships have held that FIR is not an encyclopedia of facts. It is only to report an offense. Now the police is to investigate and find out what is the offense, to what extent, who are involved, etc. Now, my lord, so far as I am concerned, or for that matter, my lord, so far as the court is also concerned, my lord, but at this very stage, my lord, please consider, my lord, whether, my lord, the FIR is to be scrutinized with precision or not.
In support of the submission that the court owes a duty to look into the FIR with care and little more closely. Stop. The court also owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments made, comma, if need be, comma, with due care and circumspection, try to read in between the lines. Stop. The court, while exercising its jurisdiction under Section 482 CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the intention/registration of the case, as well as the materials collected in the course of investigation. Stop. Reliance has also been placed, paragraph, on the judgment delivered by the High Court of Bombay. Prayer has been made to permit the investigating officer to continue with the investigation and revert with a report. Stop. Paragraph. I have heard the submissions made on behalf of both the parties. Stop. The matter is at an interim stage. Stop. Paragraph. The petitioner has already obtained bail from the competent court. Stop. The evidences, that is the CCTV footages, are already in the custody of the investigating officer. So the petitioner is being tried is of wrongful restraint and abatement. Stop. The complainant, in her complaint, has mentioned that she was made to sit inside the EPABX room, and the petitioner blocked her way and asked her not to disclose any fact before any authority and not to make a hue and cry. Stop. There is it has been mentioned that the petitioner, along with a few others, tried to take away her bag and mobile phone and make her sit in and mobile phone, but somehow she managed to leave the room. Stop. Next. Whether the ingredients disclosed in the complaint can be treated as wrongful restraint or abatement will be decided. Stop. At this stage, it does not appear that the investigation will suffer in any manner if the same is temporarily stayed till the 17th of June 2024. Stop. Let the report of investigation that has been made till date be placed before the court on 10th June 2024, when the matter will appear before the regular bench. Stop. Next. List on the 10th.